who are joining us online, as well as participants who are here with us in the room at the University of Kentucky. Our presenters will provide an opportunity for questions this afternoon, and we welcome questions from all of our participants. Please type your questions in the chat box if you are online, or you may use your mic. Should you have any questions about CEUs, you can contact me. Please take a moment at the conclusion of the seminar to complete our brief evaluation. The evaluation will be sent to your email address after the seminar. It is really helpful as we plan for upcoming seminars. Now, to introduce today's speakers. Mark Newton is a self-advocate, educator, organizer, and former member of the Protection and Advocacy Developmental Disabilities Advisory Board, the PAD Board. Heather Sneed is a personal assistant and a panel participant today.
And a friend.
And a friend. Harold Kleinert is the Director Emeritus of the Human Development Institute at the University of Kentucky. And finally, Jeff Edwards is the Director of the Kentucky Protection and Advocacy Division. The title of the seminar is A Brief History of Developmental Disabilities. What have we learned from the past 50 years? I'm now going to turn it over to our speakers.
Thank you, Walt. I'll go ahead and just do a brief summary of history, but I think the most powerful part of what we have to share is not in the policy and legislative markers and everything else that have happened over the past 50 years, but the personal stories of the people who have lived that time. And when we say 50 years, we really mean that. I actually started working in a state facility almost 50 years ago in Kentucky, and so I have lived this history too, but I've lived it from the perspective of a service provider and not as a person who's receiving those services. And I think the best way to share this understanding of the progress we've made, as well as the challenges that we still have, is by giving you a glimpse of the history in terms of, in terms of what you would find if you were to read it in a text or whatever. But secondly, learn how shared stories can have an impact on real change. And because I really think it's the personal stories of lives lived that really gives us the full impact of where we've been and hopefully where we're still going. And then finally, becoming familiar with key challenges to sustaining the progress we have made. I have to apologize up front. I'm a little bit under the weather, and if I start uncontrollable coughing, they will just dismiss me from the panel, but I'm heavily medicated with all kinds of good medications to hopefully get me through this. So hopefully I won't make anybody else sick. Really interviewing for my second job, it was a cold winter's day in December 1970. And this kind of gives you a sense of where we have been. I had worked previously with children with severe emotional disturbance in the old Central State Hospital, and was now interviewing for a second position. And I had gone to a state institution for youth and young adults with intellectual disability, the old Frankfurt State Hospital. And this was a job interview. It was a very cold, gray day, not sunny like today. And all the leaves were bare, kind of like the California Dreaming song, for those who can remember the mamas and papas. And I was taken into the place where I was to meet the students that I was going to have. And when I went into a room, maybe 3 times the size of this room, maybe 4 times the size of this room, and there were 50 boys and men, maybe half of them totally naked, others with some form of dress on. The only furniture, and I'm not making this up, and this is in my lifetime, in this state, about 30 miles from here, the only furniture was wooden benches around the room, and then it was a concrete floor. And I remember being in a little bit of shock, and the floor kind of slanted down, and there was a drain in the center of the floor. And so I said, well, what's that drain for? And of course, they explained what the drain for was to wash down feces and urine. And it wasn't that bad people worked there. It is that was our society's perception of what could be done for the lives of people with significant intellectual disabilities. A little bit before my job interview, Burton Blatt, and I've given you the link to Christmas in Purgatory if you'd want to see that, wrote a photographic essay called Christmas in Purgatory. And the book Christmas in Purgatory, it really documented what was happening in state institutions all over the country. It wasn't that Frankfurt State Hospital was any worse or any better than any other place. It was a general condition for the lives of people with significant intellectual disabilities. And one of the photographs in his book, I put up here, that's pretty much what I saw that day. Bigger room, more people, but that's what I saw. I did not take that job, all right? Now, things have changed. I would like to tell you they have changed dramatically they've changed for every person's life. That is not true, but things have changed. And so where do you think the chief source of the power for the change occurred? And how do people access the questions, Walt?
I just launched the poll.
Okay.
And they see it on the screen, as you can see it up there.
Yeah.
And then they pick things.
Yeah. So you thought you'd just sit here, ha 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 ha. All right. In the 50s and the 60s, which of the following had the greatest impact upon creating legislation and programs for children and adults with the most significant disabilities? Congress. Congress is always doing things. Parent activism, researchers, or growing public awareness?
All the people online picked parent activism, but someone picked growing public awareness.
Growing public awareness was clearly a factor, but far and away the most important was parent activism, because can we turn off the poll?
I just
Great. Okay. Because at that point, if you were a parent of a child with a significant disability, you had two choices. You could place your son or daughter into a state institution like that, or you could keep your son or daughter at home. But understand, your child was not allowed in public school. The disability was too severe. The disability was too severe. And so parent groups, most notably the National Association for Retarded Children, now the ARC, started programs for children who were excluded all over the country. The job I did take was not that state institution. The job that I did take was with the St. Joseph County Council for Retarded Citizens in South Bend, Indiana, in a school started by a local ARC association for children in the state of, actually in South Bend, Indiana, who were excluded from public school in Indiana. And Kentucky better not think they're any better, because we were also excluding kids from public school for the same reason. And in Indiana, the children I taught had this label: sub-trainable. Dogs are trainable. These are children who were below trainable in the eyes of the state of Indiana. Okay, but we, at least because of the parent advocacy, at least there was a program for them to go to, so that they had a choice rather than just keeping their child at home or sending them to a state institution. Okay. Now, another thing that was actually pretty important was the Brown versus Board of Education decision in 1954. Does anybody remember what that was about? Brown versus Board of Education? Yes.
I believe it's about segregation.
Yes, it's about, and separate is not equal. So what the heck did that have to do with, what did that have to do with the rights of kids with significant disabilities who were excluded from public school? Well, nothing, because it was separate but equal. But when the Supreme Court writes a decision, they also write a rationale. And this is what they put in the rationale. In these days, it is doubtful that, remember, parents are reading this. In these days, it is doubtful that any child, didn't say child who was African American, it didn't say a child who was another race, it said any child may reasonably be expected to succeed in life if he's denied the opportunity of an education. And of course, the parents of these children, their children were denied that right to education. Such an opportunity where the state has undertaken to provide it is a right which may be available to all on equal terms. Supreme Court wrote that in 54. This Federal Special Education Act that really guaranteed that right didn't come to 1975. But don't think that the seeds weren't planted, okay? And then also in that same thing, that same opinion on Brown versus Board of Education, to separate students from others of similar age and qualifications solely because of their race. And you could easily read into that if you're a parent of a child of a significant disability, because of their disability, generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. So the seeds were planted. And also, you know, as a person who research and training did play a part, increased public awareness, whoever answered that certainly was an important element. The fact that President Kennedy had a sister who had intellectual disability and started the President's Committee on Mental Retardation, which eventually became President's Committee on Intellectual Disability, also played an important role. But so the seeds are being planted. Okay, now it wasn't though until 1972. You will get some musical accompaniment here. A brief interlude.
That was a participant.
Okay. It wasn't until 1972, and I was happily teaching in South Bend, Indiana, that a group of parents and advocates actually sued a state, the state of Pennsylvania, for the fact that their children were denied the right to go to school in the state of Pennsylvania. Now, you cannot sue in federal court unless there's a federal law that's involved. There was no federal law saying you had a right to go to education if you had a significant disability, or if it's a constitutional issue. So, is there a right to education explicitly contained in the U.S. Constitution? And your question is yes or no. And I would argue, well, if there's not, why didn't the court just throw the case out? So at any rate, so you answer the question, is there a right to education explicitly contained in the U.S. Constitution? Audience participation.
Two yeses, 6 no's.
Yeah. Now, and so the answer actually is no. So how could the parents sue and the advocates sue and not be thrown out of court? Okay, can we? Okay, we're going to turn it off in just a second. The reason that you could sue was because there was a constitutional basis, not an explicit right to education, But there is a right to due process, which means you cannot be deprived of life, liberty, and property. And remember, in Brown versus Board of Education, the Supreme Court had said, it is doubtful that any child may reasonably be expected to succeed in life if he's denied the opportunity of an education. So that's the Fifth Amendment due process. And the 14th Amendment is equal protection. Such an opportunity where the state has undertaken to provide it is a right which must be made available to all on equal terms. So they were able to, can that turn off?
I did. I think, can you click off on your side?
Okay.
Exit.
Okay.
Right there.
Oh, good.
There you go.
So due process and equal protection was the case. It was in Pennsylvania. It was 1972. He said, what the heck? That's ancient history, Well, the state of Pennsylvania, being a good state, said, and they listened to all the experts saying, all children can learn. There's no children who cannot learn. These children have a right to be in public school. And the state of Pennsylvania said, yeah, we agree, we'll do it, we'll educate all children. All right, became the first state in 1972 to agree to that. Well, I was teaching in that school in South Bend, and we were having a faculty meeting in my classroom. We had a big table, and everybody was sitting around it. And the principal came running in, out of breathless, and he says to us, "You won't believe what's going on in the state of Pennsylvania." And we said, "What?" He said, "A federal judge has just ruled that all children with mental retardation was the term used then." Have a right to go to school in Pennsylvania. And we were just sitting 2 states over with children who were not having a right to go to education. And we knew it was coming. And it really was coming. There were several other major right to education cases. One in the District of Columbia, where the District of Columbia was not like Pennsylvania. They didn't give up. They fought. They said, we don't have the money. And the judge said, I don't care. You will take the money you have and you will proportion it equitably to serve all kids. And even there were like 22 or 23 of these federal court cases. And finally, there was one in Kentucky too, in here, the Bluegrass Association for Retarded Children also. So Congress saw okay, why isn't it going down? I'm frozen, Walt. Page down.
Right or left?
Nothing is working. It wasn't that Congress, out of the goodness of its heart, decided we're going to pass a law for all, to serve all kids with disabilities in the public schools. It was because of all these right to education cases, and then finally in 1975, there we go, excellent. Finally, in 1975, thank you, we had the passage of the Education for All Handicapped Children Act. Okay, but those are the events leading up to it. It wasn't until September 1, 1977, that the law came into effect, because Congress has to write regulations. And at that point, I was teaching in the state of Illinois in Champaign-Urbana, and into my class that day walked or wheeled 7 students, ages 14 and 19. None of whom had been in a public school program until that time. Okay, here are the key concepts of the Education for All Handicapped Children Act. One of them is a free, appropriate education. All right? Now, your third question, appropriate. What the heck does the word appropriate mean? Does it mean the best possible education that we can envision, the best possible education we can provide? And there have been 2 Supreme Court decisions that have one just in the last year that have tried to define what the word appropriate means. Is it the best possible? Yes or no?
2, 2, 3 yeses, 5 noes.
Okay. Well, let's see if I can turn myself off. It actually is no. It may surprise you. Okay. And what are the two Supreme Court decisions that okay. You know, I think what happens, Walt, when I turn it off, I lose the ability to, there we go. There, okay. Got it. Thank you. There were two Supreme Court decisions. The first one was Raleigh back in the early 80s. And that was a child with a severe hearing impairment. And she was doing very well in school. And but she had a sign language interpreter and who was helping her. And the school said, you know, she's not really even paying attention to sign language interpreter. She's doing speech reading. So we're going to take the sign language interpreter away. And the parents sued and said, well, wait a second, you know, she's entitled to all the things that can really help her. Who did the Supreme Court decide with? Who do you think, the parents or the school district? School district. And the argument was, okay, she was doing very well in school, okay? She was making, I think she was making straight A's, but she was certainly making passing marks. And they said, what the school has to provide is an education. If you're a student who's progressing from grade to grade, you know, in your regular education classroom, the school has to provide an education reasonably calculated to enable you to earn passing marks, passing grades. Okay, not the Cadillac of all the possible services that you could imagine. Okay, and then if it was a child with a more severe disability, it said it had to confer some educational benefit. Well, the some educational benefit became a huge issue in another Supreme Court case, the Andrew case, which was decided last year. And the argument from the school system is, you know, well, the child is making a little bit of progress, and the parents were saying, yeah, but the goals are the same year after year after year after year. Who did the Supreme Court side with on that one, do you think?
School.
Pardon?
Public schools.
No, the parents, because they said this. All right. They said the Raleigh case, the first case, had set a standard for a child who was in a regular classroom or who was participating, fully in the regular curriculum. But for a child with a more significant disability, you had to provide more than minimal bare effort, bare progress. And it said, this is what the reading is. So even though it's appropriate doesn't mean the best possible, it does mean this. His educational program must be appropriately ambitious in light of his circumstances, just as advancement from grade to grade is appropriately ambitious for most children in the regular classroom. The goals may differ, but every child should have the chance to meet challenging objectives. So it had to be an equally comparable challenge. And then, this is pretty strong language, Carolyn Wheeler, when all is said and done, a student offered an educational program providing merely more than minimal progress from year to year can hardly be said to be an education at all. So even though appropriate doesn't mean the best possible, there are clear standards of what schools have to do. Okay, other parts of the zero reject. You don't have to answer this question, but does zero reject really mean all kids? Aren't there some kids who may be so profoundly involved that the school has nothing to offer them? What do you think?
Want us to answer?
What?
You want us to answer or just think about it? Do you want us to answer or just think about it?
Well, you can answer it, but I didn't give you a formal question.
I think at that time, school systems didn't believe they could educate all children.
Yeah.
At that time.
Yeah.
Probably still even today, but more so then.
Yeah, and actually there was a court case that went all the way up to appeals courts, Timothy W. case, in which a school system argued, well, we have a child who's so severely disabled, they are non-ambulatory and nonverbal, and we don't know if the child can hear or has vision, and we think the child has a severe intellectual disability, and surely Congress doesn't mean that child. And the appeals court said, read the law. All means all. Okay, so it really did mean all. Due process, all those rights and things about, due process hearings and mediation and all of that is contained in the law. One of the reasons that all that is in federal law is because this is a rights-based education. Courts had to shape it. Parents had to sue. And so all that due process language is a heritage from that. Non-discriminatory assessment, you have to use more than one assessment. You have to use things that are not culturally biased. Least restrictive environment. All right, our next question. Does the principle of least restrictive environment mean that all children and youth with disabilities are to be educated in the regular classroom? Yes or no? Right.
Putting the question up here.
Oh, okay, she's putting the question, yeah. Pardon?
We should be voting. Our aides should be voting.
Yes.
You can log in on your computer and vote. We have 8, we have 9 for no, and we have 1 for yes.
Okay. Well, I would like it to mean yes, but it doesn't. It doesn't mean yes. If you have voted no, you are right. And let me actually give you, excuse me, this is what the language, and this language has been there since the law was enacted in 1975. I can tell you it's interpreted a lot. It's interpreted differently now. When I was teaching in the 70s, for most kids with severe intellectual disabilities, they were in separate schools. So we didn't really take this literally. We didn't really think it meant what it says. But it does say, to the maximum extent appropriate, children with disabilities are educated with children who are non-disabled, and that special classes, separate schooling, or the removal of children with disabilities from the regular education environment occurs only when the nature of severity of the disability is such that education in regular classes with use of supplementary aids and services cannot be achieved satisfactorily. That's very interesting. It should be to maximum extent appropriate. Remove only when you cannot achieve the education satisfactorily with the use of supplementary aids and services. So if you're not using the supplementary aids and services, you're not doing the federal law. Does it say the child has to be working on exactly the same goals as everybody else? No, it does not. Okay? And then finally, shared parent and the student decision making. For transition age youth, they have to be included in the IEP. But for many youth, it's simply a matter of sitting there while other people talk about them, about their future. For parents, they are also to be included, but often the school brings in a draft of an IEP. The parent may not have had any influence in terms of developing. I would argue that if you really want shared parent and shared student decision making, you have to involve parents. You have to involve students well before that actual meeting. Parents have to have input before the meeting. The meeting is way, way, way too intimidating to really expect people to speak out at that meeting. You have to get their priorities. You have to practice with the student in terms of their contributions before the meeting, or it's not shared parent and student decision making.
And Harold, and the practice that most school districts have of telling parents when that child is 18, you can no longer attend their ARC meeting unless you're their guardian, is very problematic for people too, because it forces, it's another way, it's an intimidation factor that I've always thought that what we were doing to parents, and then to make them think that they are not part of that process. And it further alienates the student
Yeah.
from the process.
No, you're absolutely right. Of course, the parents can be a part, can be a part of that process. The only other thing we'll cover is real quickly so we can really get to the meat of our program. The right to education is critical, but life is more than school. Now, if you're in school and you're in a graduate program or whatever, and you're also, if you're doing all, I mean, you may think that's all life is school, but life is much bigger than that. And so, what is the source protection from discrimination, other aspects of life? This is actually predated 94-142, the Federal Special Education Act, or IDEA. Section 504 of the Rehabilitation Act, we'll just real quickly. To be Section 504, you have to be kind of buried in the law. That means there has to be 503 sections in front of you. But I would argue that no sentence has meant more for the rights of individuals with disabilities in our society than this one. This is Section 504. No otherwise qualified handicapped individual in the United States shall solely by reason of his handicap be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Who receives federal financial assistance?
Public schools.
Public schools. Governments, local governments, parks and recreation. All kinds of agencies in our country receive federal financial assistance. Okay, and the definition under Section 504 of disability is broader than the definition under IDEA. So there are some children who qualify for 504 plans in our country who may not qualify for special education because of the broader definition. Okay. Now, the problem with Section 504 is that it didn't cover private, the private part of our society. Society did not receive federal financial assistance. And really, the Americans with Disabilities Act was really passed to take the protections of 504 and apply it to all society, except the next question. But the last question, which of the following entities is not required to conform to the accessibility requirements of the Americans with Disabilities Act? And there are your four choices. Well, you have to, you have to.
Why can't you just do a poll of us in here?
But see, there's people, yeah.
Our voices are not getting heard.
Oh, aren't you getting, yeah, I thought you had a chance you could respond to the poll.
You have to log in.
You can just click that link that I sent last night about 6:30.
Everybody has it.
I'm sorry for the people who are not here. We're making you second-class citizens. All right.
Discriminated against us.
Okay, well, mark it down in your head.
It's like an art meeting, Carol.
I'm going with the first one.
That's exactly right.
I'm going with the first one. I think Walmart's too big.
We've got one answer for fine dining restaurants, and we've got 10 answers for places of worship.
That's correct.
Okay. Yes. Now, why do you think places of worship are excluded from the accessibility requirements of the Americans with Disabilities Act? Places of worship aren't important in our society. Religion doesn't have an important, faith doesn't have an important role. Why is it excluded? Congress says, oh, nobody goes to church anyway. You know,
We have a response from online,
Mhm.
and the response is from May Parish, and May Parish says, separation of church and state.
well, maybe. And first of all, that person is absolutely correct. That's what Congress was arguing, separation of church and state. But I would argue that religion and the ability to participate in the faith of your choosing is a fundamental right in our country, and to exclude places of worship, most places of worship do conform to accessibility requirements. To exclude them from the need to do that, I think was, in my opinion, only Kleiner's opinion, an error. Not that Congress would ever make a mistake. Okay. Now, why aren't I going forward again?
Double click on the.
Okay. Good. So what we have seen, and this wraps us up, the section, what we have seen over the course of 50 years, actually segregated schools is not the first step. The first step were kids with severe disabilities excluded entirely. Then segregated schools, okay, and kids with severe disabilities being included in segregated schools simply because they had severe disabilities. Then integrated programs in regular public schools with maybe a little bit of contact with kids. Then the movement towards kids being included in general education classrooms to the maximum extent that they could be, really trying to implement the real intent of least restrictive environment. Student-directed IEPs and self-advocacy, students, and you're seeing this more at the high school level, kids really not just being present and participating, but leading it. And then finally, post-secondary education, there's now like 270 colleges offering carve-out specific programs for students with intellectual disabilities on their campuses. The University of Kentucky is not one of them. I tried. Vanderbilt is, who we're playing in football this weekend. I hope Kentucky wins. Also, paradigms, another point from shelter workshops. I have supervised individuals with significant disabilities, including people who lived in state institutions as shelter workshops. I think shelter workshops have had a place in people's lives, but we know so much more to go beyond that in terms of supported employment programs and now customized employment that are really matched to both the employer's needs and the worker's needs. And then from living in institutions and living in horrible institutions, not just in Kentucky, but nationally, to moving more towards group homes, to more supported living, and then individually determined and controlled budgets where individuals can hire and fire their own support workers. All of these have been shifts that have occurred. Okay. Now, I took an awful long time, more than I expected. At least I didn't put the panel to sleep.